drugs, injuries, and abuse across the state of Alabama. The attorneys, proudly sponsored by Hollis, Wright, and Couch, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the Hollis, Wright, and Couch law firm and host David Lamb.
Hello and welcome into the attorneys. Appreciate you spending your Sunday evening with us. For the next half hour, the goal here is to get our panel of experts to answer your questions. For that really to work, you need to get your questions to us. The way you can do that is by calling, texting, or emailing us. That information throughout the program will be on your screen. So we welcome you to do so. Joining us to lead the effort tonight, Josh Wright of the firm Hollis, Wright, and Couch. Good to see you, sir.
You too. Hope you had a great week.
Indeed, I did.
You know, this is a topic, David, DUIs in Alabama, that is unfortunate that it can impact lots of folks in Alabama. We have a lot of DUIs in Alabama. We have brought one of the experts in the state, Joe Basgier from Bloomston and Basgier, on with us. He's been on our show before. He's a knowledgeable guy that knows this area of the law, and I think he's going to do a great job. So first, thank you for coming on and being on the show.
Absolutely, and thank you for having me again.
I think the easiest way to start this whole conversation is kind of to give an overview of what qualifies as a DUI under Alabama law. Sure. And if you can start there, maybe we can kind of delve into it and work our way through it.
And it is an important topic, and it is the kind of crime that you often see just about anybody being potentially liable for. So a DUI is driving under the influence. Now, most people usually think about that in terms of alcohol, and that's true. The legal limit in Alabama is 0.08%. That's 0.08% of your blood alcohol volume. You can also be charged with a DUI for just being under the influence of alcohol, which is typically going to be based on the opinion of the officer that's dealing with the stop. You can also be charged with a DUI for being under the influence of a controlled substance. Marijuana, Oxycontin, Xanax, even prescribed pills. If you're on them to a level where you're intoxicated, that can lead to a DUI. Now, if you're in that kind of situation, it's often going to involve a blood test, so it's a little more complicated for the police. But that's sort of where we go, intoxicated on any substance.
Now, I think a lot of folks, Joe, believe that you have to register, that everybody hears this 0.08 blood alcohol concentration, that you have to register that in order to be found guilty of a DUI. That's not necessarily the case, is it?
No, it's not the case. A lot of times what you'll see in the past, before these new laws have been passed, which we'll get to later, people would refuse to take a breathalyzer test. Now, in the state of Alabama, we have what's called an implied consent law, which means that it is assumed that anyone driving on the roads of Alabama will submit to a breathalyzer test if asked by a police officer who has probable cause. But, you know, sometimes people sort of think they may have a problem with their intoxication level and they can refuse to take that test. And if they do, the officer will just observe the demeanor of the person. They may submit to field sobriety tests, see how they do on that, and he can develop an opinion as to their intoxication, and they can get arrested for DUI that way.
And in fact, isn't it accurate that if you register below a 0.08 in circumstances where you did take the blood alcohol concentration, there are some presumptions in place where you could still be convicted of a DUI?
Possibly.
Okay.
And in reality, usually you're going to see that when there's some suspicion that you may have alcohol in your system below a 0.08, but you may be on some other drug, and it's a combined influence situation.
David, that implied consent law that Joe's talking about is important for people to understand, because although they may be able to refuse, for example, at the side of the road, a field sobriety test, when they get to the station and they're asked to submit themselves to some form of blood alcohol concentration test, like a breath test or a blood test, if they refuse that, they're guaranteed to lose their license for at least 90 days. Isn't that fair?
In the past, they're guaranteed to lose it for 90 days, and now there are more substantial penalties for refusing to take that test.
Is the field sobriety test, is that the one you see folks walking a line?
That's right.
And so the breathalyzer is actually something that you is that what the thing that you blow into, that deal?
Correct.
Is that the difference between those two?
Well, so here's how it works. Okay. When you're on the scene, when you've been stopped by an officer for suspicion of drunk driving, he will start going through these steps of putting you through the field sobriety tests. And the reason that he's doing that is because he is trying to establish probable cause for you being intoxicated, okay? Some of the tests that they administer on the scene are actually not admissible in court. The most famous one is the horizontal gaze test, where they take the pen. Everyone has seen this before. And they go like this. The trick is, once they get to about right here, your eye supposedly twitches, and that may tell them that you're intoxicated. It's actually not scientifically valid, and it's not admissible in court, but they use that sometimes for establishing probable cause. Now, if they feel like they've done that they've established probable cause to arrest you for driving under the influence, that is when you're taken to a jail and you're asked to submit to a breathalyzer test.
There are also breath machines that can be used on the side of the road. Can you talk just a little bit about that and whether those are even admissible?
They aren't. It's a portable breathalyzer test that some officers will have and will ask you to take. Sometimes if you haven't had anything to drink, the officer for some reason thinks you're intoxicated, it's a good idea to go ahead and blow on that in the scene. You can go ahead and register a .00 and he'll let you go. But they may ask you to blow on that at the scene in addition to the field sobriety tests in a furtherance of their effort to establish probable cause. Okay, but you're right. It's a device that's not scientifically valid, and so it's not something that would be admissible in court to try to convict you.
A question that we have here: how many drinks does it take usually for someone to be over the legal limit?
It's really, really difficult to say. There's so many factors that go into it.
We could do a whole show on that topic alone, couldn't we?
We could. We could probably bring in a medical doctor and a scientist to come in and talk about it. But it's going to depend on your height and your weight, your metabolism. It's going to depend on, believe it or not, how often you drink, because I believe you can actually develop a certain level of tolerance to alcohol. And it's going to really depend on what you've had to eat. That's a huge factor on what your blood alcohol content is.
I think the short answer there is there really is no definitive way to indicate how many drinks someone can have before they are intoxicated. The reality is people just need to use the best judgment that they possibly can in these circumstances. And if they're consuming alcohol, there's so many other options other than driving a vehicle.
Right. And you touched on it, but another question on it, so let's just to make sure that we're clear. If does the driver have to take that roadside sobriety test or the breathalyzer?
Go ahead, Joe.
Okay, so the driver does not have to submit to field sobriety tests or anything along those lines on the scene at the side of the road.
Okay.
He can refuse that. If the officer still decides to perfect an arrest because he's established probable cause, you're brought to the jail. The implied consent law tells us that you must submit to a breathalyzer test at that point, okay? Now, they can't hold a gun to your head and force you to blow, so you can technically refuse, but the penalties for refusing at this point are very severe.
Right.
The old adage used to be, if you think you're drunk, don't blow. If you're not sure, don't blow. But that analysis is gone. Okay?
Right.
There are other ways, too, to establish probable cause at the scene other than the field sobriety test, where you can still be arrested for DUI. For example, they could use the driving that you exhibited before that event to help establish probable cause. Sure,
and look, another thing that you'll see, I think probably every police report I've ever read relating to a DUI will talk about the physical appearance of the offender. They'll talk about bloodshot eyes, slurred speech, smell of alcohol, the odor of alcohol. It's a checklist that's just really easy for these officers to go down that can establish probable cause.
All right, time for our first break of the evening. As we head to break, we'd love to hear from you. You can call, text, email the show. We'll pass the questions along. Also, you can find the firm Hollis, Wright & Couch on Facebook. Just search that term, Hollis, Wright & Couch, and on Twitter, Hollis_Wright. Stay tuned. The attorney's coming right back.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, Call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
Car crash cases.
Hello and welcome back in to The Attorneys. Our topic of conversation tonight, DUI cases. A reminder, throughout the program you'll see ways for you to call, text, email the show. We'd love to hear from you. Josh, in 2010, these numbers here, right around 13,000 individuals in Alabama were arrested for driving under the influence.
And I was talking with Joe offline, and it sounds like the statistics are even higher in 2011.
I've read somewhere in the range of 16 to 17,000 arrests for DUI in 2011.
So there's a significant number of DUIs going in there. You know, it's interesting, David, we've done some shows on dram shop litigation or alcohol-based litigation. Our firm actually works with Joe's firm in some cases where DUIs cross over into causing significant injury to individuals in a dram shop case or an alcohol-related case. And so the two types of law, the criminal side and the civil law, sometimes, unfortunately, come together, and the parties have to work with one another. We rolled in with a firm fact that I think is an interesting fact that folks need to understand about the importance of getting to counsel immediately. Can you explain kind of in general why that first 10 days is critically important after you're arrested for a DUI?
Sure. So within 10 days of the arrest, you really need to get with the lawyer and get on protecting your driver's license privilege. That's a set time period that you have to make your request with the director to protect that. And also, you also have a limited amount of time if there's been a refusal of a breathalyzer test to protect your license as well. We can file essentially a lawsuit against the Department of Public Safety that can stay a license suspension while a criminal case is pending, and in some cases get that suspension period reduced. Okay, so it's absolutely crucial that we get on that immediately after the arrest.
So what do you recommend? I mean, do they call? Is it their first call to you guys? Is it something they do the next morning when they bond out of jail? I mean, just get it done quickly. Is that kind of the opinion?
Absolutely. In fact, believe it or not, I get calls 11, 12 o'clock at night where my client is calling me while the officer is behind them walking up to the car, which can be a good idea as well. I've been able to talk clients through their interaction with the police officer.
Now, the penalties for DUI are significant.
Correct.
And they have actually, with some recent legislation, got even more significant, have they not?
That's correct.
Talk to us generally about DUI 1, DUI 2, and those penalties, and why it's important to have counsel to kind of walk and lead, guide, and direct you through the process.
It's so important. A DUI can have a dramatic effect on your life. It really can. So the way this is set up is the state of Alabama increases the penalties for a DUI offender with each successive conviction. Okay, right now a first offense DUI, you can be subjected to up to a year in jail. You can be subjected to a fine that can be as high as $1,200. With each subsequent offense, the penalties go up. Second offense, your minimum fine's $1,100. Mandatory minimum 5 days in jail. Third offense, that goes up to 60 days. Fourth offense, you become eligible to be charged with a felony DUI, which comes with another host of problems, along with mandatory minimum jail time as well.
I know a lot of questions that we sometimes get when we do these shows is, if I've had a DUI in Mississippi or Georgia or Tennessee and then I have one in Alabama, do those work together?
Yes, out-of-state convictions can be used to, quote, enhance your penalty for a DUI in the state of Alabama. Although the magic number right now is 5 years, okay? The state's not going to hold a conviction against you, particularly if it's out of the state, if it's older than 5 years.
Another question we always get is, I was in my vehicle, and I was not actually operating the vehicle, but the officer had probable cause, or claimed he did, to arrest me for DUI, and I've been charged with a DUI. Of course, you know, we don't handle the criminal side of the cases.
Right.
They get forwarded to firms like you guys. But can you talk to us about whether or not that can happen, et cetera?
Okay, so that can happen, and it really depends on the circumstances. If, for example, you're parked in a parking lot, you're in your car, let's say you've passed out, if the key's not in the ignition, I don't think you can be charged with DUI. I've seen people get charged with DUI in that circumstance, and we've been able to prevail, okay? If that key is in the ignition, that means you are in actual physical control of that vehicle and you're eligible to be arrested for DUI. A lot of times those kind of calls arise because someone has seen the individual, I hate to say it like this, but it happens, passed out in the car, and they're concerned about that person, and that's how the police get there. Now, I've also seen cases where, unfortunately, someone's so intoxicated that they come to a red light and stop, and they don't move, okay? That's a different scenario. That's clearly someone who's in actual physical control of the vehicle, and they'll be eligible for a DUI conviction potentially.
Another great reason, David, just get counsel quickly if you unfortunately have gone through this circumstance. And of course, on the show, we always, mention we're certainly not promoting people to go get DUIs. What we're trying to do is provide a service for folks that have unfortunately found themselves in this circumstance, kind of what they need to do in order to protect themselves.
On that topic, a question we've got: if I intend to plead guilty, do I still need an attorney?
Absolutely. Absolutely. You should never go through the criminal process without an attorney. You will get abused by the system if you do, okay? You're not going to know what kind of options are out there available to you. For example, many municipalities and some county-level courts have what's called a deferred prosecution program now for first-time DUI offenders. This is something that's very valuable to someone that's been arrested with a DUI. They go through a program, they go through drug and alcohol testing, and they go through counseling, some community service, and if they do everything satisfactorily, the DUI will be dismissed at the end of that. And we've been successful in advocating that program for our clients in the past. It's a very valuable option. On the flip side, when you start getting into your second offense, your third offense, where these penalties really start to increase,
Right.
You need a lawyer there to negotiate it on your behalf. It's crucial.
Yeah. All right. Time for our second break. One segment remaining of the attorneys. So time for you to get your questions to us. We'd love to hear from you. Also, a reminder: find the attorneys, search the term, find them on Facebook, attorneys_Wright, and you'll find them on Twitter as well. Stay tuned. Final segment of the attorneys coming right up.
I'm Greg Foster with the law firm of Hollis, Wright & Couch. If you ever have to file a lawsuit, we want you to be informed of your legal rights. Some legal terms can be confusing, especially ones you may never have heard of. That's why in this week's Legal 411, we're answering the question, what is subrogation in a contract with an insurance company? There's often a subrogation provision. This means in a personal injury lawsuit, if you receive a settlement or verdict in your favor, you may actually have to pay your medical or health insurance company back with some of the proceeds you receive. This payment would cover a portion of the amount of insurance that the company paid for your medical treatment and your injuries. So even though you pay for your insurance and someone else caused your injury, you will have to pay your insurance company something. And your insurance company owes you nothing in return. At trial, the person you are suing for causing your injury will be able to submit as evidence the fact that you have medical or health insurance, and the jury may use this evidence against you. To top it all off, a defense attorney will likely call a representative from your insurance company to testify against you. They will ask the representative to confirm that you have insurance. They'll suggest that you are okay or not hurt since your insurance company paid your medical bills. They will also tell the jury that because you have insurance and you do not have to pay for the full hospital bill, they will suggest to the jury that because your bill has been paid, you are not severely injured. All of this used to be inadmissible in court. The jury wasn't allowed to hear this evidence because the information could unfairly hurt your case. But now the rules have changed. Nevertheless, remember that the rules also allow your total medical bill charges into evidence, which may be beneficial to your case. These total bill medical charges demonstrate the level, severity, or magnitude of your injuries. If you have $100,000 in medical bills, you clearly were more than just scratched up as a result of someone's negligence. Overall, when it comes to subrogation, you need to know your rights and consult an attorney as soon as possible to help you win your case. Please remember, call, email, or text to the attorneys is free. All of us at Hollis, Wright & Couch want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on Alabama's 13.
Welcome back into The Attorneys. Our final segment here discussing DUI cases and your rights in relation to that. Josh and Joe, when we went to break prior, the firm fact was about some recent legislative changes when it comes to DUI?
Yeah, and I was mentioning before the show that I was actually kind of involved in some of those hearings this past legislative session. Joe, if you will, I think it would be impactful for people to understand that the legislature oftentimes will make adjustments to the DUI laws, and last session was no exception. There are some changes that took place, aren't there?
There are some significant changes that can have a dramatic effect on someone that's been arrested with a DUI, okay? The first is that there are now increased penalties for certain offenders in a DUI situation. The second is the ignition interlock system, which we'll get to in a second. I think we should probably focus on the increased penalties first, if that's okay with you. You know, the magic number for the increased penalties is 0.15%. If your blood alcohol volume is 0.15% or higher, you're going to be subjected to these increased penalties.
Even for a first-time offense, correct?
Okay, so here's the deal on a first-time offense. If you're below a 0.15%, your sentence range could be anywhere from 0 days to 12 months in jail, any portion of which could be suspended. You're not likely to spend time in jail on a first offense DUI unless there are some significant injuries or other surrounding circumstances. If you blow above a 0.15% now, the judge is required to give you a 1-year sentence. He doesn't have any option to deviate from that. That doesn't mean you go to jail for 1 year, but it's not going to be 90 days, which we used to see sometimes. And that's not going to be 6 months. It's going to be a 1-year suspended sentence. After that, you start seeing the penalties doubled on each subsequent offense. So on a second offense, your minimum mandatory jail sentence is 10 days instead of 5 days. When we say minimum mandatory, what I mean by that is the statute, the law in Alabama says you must go to jail for these number of days. The judge has no discretion. You have to do it. A second offense, like I said, is 10 days. A third offense is 120 days. And it's just terrible. The fines go up as well.
Tell us about the interlock, because that's a really interesting piece of legislation that came out.
So the interlock ignition law went into effect about 2 months ago. And what this is it's a device that's actually inserted into your vehicle that you have to blow into before you can literally start your car and begin driving it. And this is to ensure that you don't have any alcohol in your system. It's kind of draconian to a certain extent, but at the same time, obviously drunk driving is a major problem and people get injured, so the state's really starting to crack down on this.
The intent obviously is to try and protect folks on the road that are not drinking alcohol from those that have a problem.
Yeah, I mean, we have just a couple minutes remaining, but is that the motivation behind the legislative changes, raised awareness or raised concern? when it comes to DUIs?
Yeah, I mean, I think so. You know, I was not directly involved, but I was there and attended some of the hearings. And I think the idea is this, that the current governor and even our previous governor believe that the DUI laws are not significant enough and they need to have more bite to them to try and curb the problem. We were talking offline. Just last year alone, some 16,000 to 17,000 people in Alabama were arrested during the year for DUI. You start to think about those numbers compared to those of us who are driving over the weekends and whatnot on the road safely, operating our vehicle, not consuming alcohol. And you start to question whether or not, you know, what the likelihood is you're going to be involved in an accident related to alcohol in your lifetime. And we've had shows on that, and you know the statistics are staggering. So the concept is, let's make these penalties more significant. Let's try and pull these drunk drivers off the road to protect the rest of us.
Now, the curious thing about this situation
We
is
have just a minute, Joe, but you can make it quick. Go ahead.
all right, these interlock devices are not going to be provided by the government. It just has to be a device that's approved by the Alabama Department of Forensic Sciences. It's incumbent on the driver to go out and find an approved device and get it installed in their car. So it's going to be something that comes from the free market system. Real quickly, okay, the things that can trigger an ignition interlock device
We're
are
about out of time. Make it quick.
0.15% or greater.
Okay.
Refusing a breathalyzer test is crucial. Having a child under the 14 in the car, and if someone else was injured.
Yes, I'm glad.
Thanks so much, man.
Interesting
Appreciate you coming
conversation.
today.
Both of you. Appreciate the time. We're out of time. This is how you can get in touch with the attorneys. Find them on Facebook, Twitter as well. Thanks so much. Have a great weekend. We'll see you next Sunday night.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis, Wright & Couch.